when we go towards Islamic jurisprudence, it is very rigid. In fact, I should tell you that it is not rigid, it is very flexible. Because in relation to the family laws, it is the most modern family law. It should be understood as a separate science of law. It needs a revisit and an honest approach to learn again. And to learn again, the most important is that we need to first unlearn. So I am very much thankful to Mayank and Legal Bites to again start something which requires actually a lot of thinking and a lot of reading, a lot of research, and a lot of academic efforts. The area related to family laws and particularly to Muslim laws, in fact, demand a revisit because it has been more than 2 centuries that we started to learn our own laws in the English perspective. Because when the English came to our country around in the 18th century, and to be very precise, around 1772, they started with administering of justice to the native people. And this administration of justice to the native people always was premised over their own family laws. Now, coming into India as Europeans, it was not that easy for them to comprehend with the legal systems what India had at those times. And let me tell you, when the perspective of English in learning the family laws, learning and to comprehend the laws of the domestic laws, or the laws of the people residing in India, not only Hindus but Muslims and other non-Muslims or other non-Muslim communities was also there. So to learn and comprehend the laws of indigenous people is always very difficult for a foreign national. So what happens during that time? Lord Hastings declared that we shall be abiding by the laws related to Muslims for Muslims, and for Hindus the laws through which they were governed for Hindus. But very interestingly, before we start a discussion on the basic precepts of Muslim law, the first idea which comes to me is that it should not be read as a law. As a law means as Muslim law or Hindu law, because in fact it is very similar to what we read and we try to understand on the aspects of being it as a jurisprudence. Like we studied Roman jurisprudence, we are studying English jurisprudence. Similarly, the Vedic jurisprudence, to be very precise, it should be Vedic jurisprudence, and similarly, the Islamic jurisprudence, which came into existence 1400 and more, 1400 and a half, or we can say 1450 years ago. So this is a continuous process in which a jurisprudence develops, and this jurisprudence, if we are able to understand the very idea of jurisprudence of whether it may be Vedic jurisprudence or Islamic jurisprudence, then only we are able to understand what Muslim law is and what is a Hindu law. So first of all, let me tell you this very important aspect, that it is neither Muslim law nor Mohammedan law nor Mohammedan law or any of the versions which have been written and which have been quoted by different scholars of law. Because the reason is, when Prophet Muhammad, peace be upon him, promulgates this faith, this new faith of Islam, it is not restricted. Very interestingly, it is not restricted to the guidance, for the guidance of Muslims only. Rather, it is said that it is for the guidance of people at large, inclusive of everyone. So that is the idea behind the Islamic jurisprudence. And therefore, the followers of this faith are called Muslims, not Mohammedans at all. This is not a religion of Muhammad. Rather, it is a religion of Islam, which means peace per se. Now, this should be the aspect of learning Islamic jurisprudence, because once we are able to understand the nuances of a jurisprudence, the idea of that jurisprudence, then only we will be able to understand why we are having such laws, which we now term as Muslim laws. Similarly, very similarly to the Hindu laws. But going before to start with the discussion, let us touch upon the historical aspect. The historical aspect is there were codified principles, codified laws available in relation to the Muslim laws, which were available in Hidayah and also in Fatwa Alamgiri. That is again a book uh, having a compilation of all the fatwas. Fatwa means decree. And this compilation was done by Aurangzeb. That is why it is named as Fatwa Alamgir. So when the British came into India, this was referred as a ready reckoner to understand what the Muslim law is all about. Another interesting aspect, what I would like to put before you is that in dealing with all the family laws, fundamental principles of family laws, or to learn about the concepts of family laws, we tend only, or our effort is only directed to convince the judge on a particular matter. Rather, as we have studied the English jurisprudence, why it is a positive law, then why, what is analytical positivism, what is the historical school saying, what is the sociological school saying, what is realism. So don't we think it is present in Islamic jurisprudence or Vedic jurisprudence? In fact, it is also very similar to the growth of English jurisprudence, which is thousands and thousands of years old. The Vedic jurisprudence, it also imbibes the views or the concepts, we can say, the ideas which were given by all these schools of modern jurisprudence. Similarly, in Islam also, very interestingly, we all have a kind of understanding that when we go towards Islamic jurisprudence, it is very rigid. In fact, I should tell you that it is not rigid, it is very flexible. Because in relation to the family laws, it is the most modern family law. When I say most modern family law, that does not mean that it has come out of a promulgation of legislations like what we feel in modernism. Rather, it is only 1400 years ago, when this was 1450 years to be precise, when this law came into existence or the jurisprudence started to develop in the Islamic way. But how it come, whether it came as something very new or it was something which came into existence by only coming into the existence of Prophet Muhammad, peace be upon him? No. It is actually again something which was in a continuous process, though the basis of this continuous process was premised over the prevailing customs, and many of the customs were recognized to be valid according to the belief, and they continue till this date. And others which were found to be against the basic tenets of religion were stopped. Like, for example, in the Arab culture, there was a kind of marriage which was called as muta marriage. It continued to a certain period during the time of life of Prophet Muhammad, peace be upon him. But after some time, he discontinued with this form of marriage. Though still it exists in some communities of Muslims, because as it happens, any law which gradually develops, which evolves, there may be people who may not be evolving to the contemporary position, but they may be stuck up with an earlier position. So that is there. And the next part, what I want to put before you is, if we want to understand the Islamic jurisprudence in a better way, it should be understood as a separate science of law, a separate science of law, a separate philosophy of law. And then only we are able to understand why and for what reasons there are certain aspects or certain positions in this legal system which we may find conflicting with the modern placement of laws, modern statutory laws, or the modern ideas. Though I don't find any of the modern constitutionalism or constitutional principle to be against the Islamic law or what the Islamic jurisprudence says. So the two ideas are there, which needs to be well taken care of. That the first is, it is a separate judicial system, separate legal system. Similarly to the very existence of separate Vedic legal system, it may be learned as a way which comes through evolution of that old Vedic system. It comes into Islamic jurisprudence. Because most of the things which we find in the Vedic jurisprudence are very well taken into Islamic jurisprudence, and they are very similar. For example, let me give you a correlation of Islamic jurisprudence and the laws it gave rise to. Laws relating, the most modern laws relating to marriage, Hindu Marriage Act. The ideas of separation, the idea of divorce is something which we can trace it, which we can trace it to the ideas of Muslim laws. Because whatever the position was there in the Hindu Marriage Act or the Hindu marriage laws were forgotten much before, centuries ago. That is again a continuous process of evolution of a law. So similarly, in the Islamic jurisprudence, in the Muslim law, there is a scope of development, a scope of evolution. There is nothing called as rigid, except, I emphasize on this word, except the matters of belief. The matters of belief related to Islam is in only in oneness of God, oneness of Allah and the Prophet Muhammad, peace be upon him, as his last messenger. Apart from this oneness of Allah and Prophet Muhammad, there is nothing in the entire Islamic jurisprudence which is not open for evolution. No rigidity. But unfortunately, in India, we have learned Islamic jurisprudence or Muslim law through the eyes of or through the ideas of English jurisprudence. So this is very good time. After more than 200 years, we are trying to find out, trying to learn the entire legal system in a very better way, in the way it deserves to be learned. And then we will be able to iron out all the conflicts what we find today related to all the family laws. I am not precisely saying about the Islamic jurisprudence or the Muslim laws, but I include every family law. If we try to understand the jurisprudence of those legal system, then we will be very much capable of understanding the laws and the principles. Therefore, let me draw your attention to the sources of Islamic. The sources of Islamic law as very much, again, very much similar to the sources of Vedic jurisprudence. In the Vedic jurisprudence, it was Shruti. And here in Islamic jurisprudence, it is the Quran, the word of Allah Himself. Again, the Shruti is something which was a divine revelation given to the rishis. Here, it is the divine revelation given to the Prophet, and later on and subsequently, which were recorded. The second source of Islamic law is the deeds of the Prophet. It is called as the Sunnah. Thirdly, very interestingly, if we find the modern jurisprudence speaking of precedence as a source of law, then again it is there in the Islamic jurisprudence in the name of hadith. Hadith is the judicial pronouncements or the decisions given by a Prophet himself on various issues which came before him. And they are available in a recorded form. So they also act as a source of future Muslim laws. Thereafter, the very important aspect which I earlier described as the Islamic jurisprudence to be very flexible is based on this very idea that the next source of law, which is known as Aima, or it is written as Ijma, IJMA. Aima is the consensus of the learned people. Now, if any law can be made on this very basis of a consensus of the learned people, then obviously it points out that there may be flexibility. There is flexibility, and the laws and the position of any positive law can always be changed, can always be evolved, is open for evolution. So that is another idea. And thereafter, there is another important source of law which is recognized for Muslim laws. Here is the difference, what I wanted to tell you today, that it is not rigid. The two reasons, because Qiyas, another reason, after this Aima, the subsequent source of Muslim law is Qiyas. Qiyas is analogy, drawing analogy. It is analogical deductions from available precedents, available positions of law, and to the extent of an individual understandings. That means if a person comes across an issue, both maybe of legal issue or any general issue or any issue related to day-to-day life transactions of life, then the idea is that he should look into what the Islamic jurisprudence says is that he should look to an answer available in the Quran as the primary source. Thereafter, he is required to find a solution in Sunnat or Hadith. And if at all he is not able to find a solution, and this includes about those persons also who are not able to read and write, even those are included. If he is not able to write or to read Quran or what has been recorded into Hadith or what has been informed as a Sunnah, he is supposed to refer to the Aima, to the Ijma, to the consensus of the learned people. And suppose even he is not having an access to these learned people for having a solution to his query, to a solution to his issue, then he is independent to take any decision. That is what Qiyas is. His own analogical deduction, that what is right and what is wrong. And very interestingly, if he does an act which is prohibited even in his religion, even in Islam, his action would not be construed as a sin, as an offense, because of his taking such a decision on his personal analogical deduction, which was necessarily based on the ideas of justice, equity, and good conscience. So, this is what Islamic jurisprudence is all about. Your conscience and individual conscience is also acceptable. Then how can we have in India such a position which seems to be so rigid? Like, for example, if we take the very latest issues, there are many issues related to the Islamic laws. And do we find such issues, such problems arising in the most modern Muslim states of the world? Or any state in the world who we say as orthodox? Do they have such issues? If the answer is in negative, then why and what are the reasons why we are always finding points of conflict, points against a common belief of the people? In fact, it needs a revisit and an honest approach to learn again. And to learn again, the most important is that we need to first unlearn what we had knowledge. We had the knowledge related to all the family laws and similarly to the Muslim laws. In fact, I tell you, there are many authorities available with us, like Mullah on Mohammedan law, Sir Abdul Rahim is there. Then we have Faizi also. So many authorities are there. But even after having these authorities on Muslim law, we need to understand it in the way it should be done. It should have been done. And within this, we need to have people doing research to find out exactly the meaning and the deductions which can be drawn from the works of more than 3,000 jurists of Islamic jurisprudence. It is nothing new. It is nothing which is very foreign to our academic uh, academic ability or academic, we can say, academic pursuits. What we can find out, it is more than 3,000 jurists and their work. Obviously it is not written in English, but at this time we can find translations, the works which were done in Persian, Arabic, Turkish. So there are many languages also in those languages in which those works were done. So it requires another visit, and to understand it in a very better way, we need to look into each and every source of law. And obviously, the most important part is that when IMA is accepted, there is no classification of people who can be termed as learned people whose consensus will be taken as a source of law. That means it opens the door for modern legislations to come. In fact, if there is any impediment, it is only because of ignorance. So that can be done. So this is what I wanted to discuss in this very introductory part of Muslim laws, how to understand Muslim laws, and specifically in India, where it is again not a new law, not 200 or 100 or 200 years ago, but it is almost more than 1,000 years that India has been introduced to the Islamic jurisprudence. Thank you.